On the first question, which is a hypothetical question, if the New Zealand round doesn't lead to consensus on releasing the document, I can only say we shall see. I mean, obviously, we'll have to report. This would be very bad news from our point of view, but we shall see. There are several options envisageable. But I think it's a very important question, and clearly, for us, it is important that we can demonstrate, as I've said, that we do what we say, as just like I've said what we do. On your second question on impact assessment fundamental rights, it is difficult to organize that before having the framework of the treaty, because obviously the questions on what to assess will be different. And since we are not yet there, I mean, it's difficult for me to give a timing on this. Yes, in the back. Gentleman with the blue shirt.
I just want to, this is Erik Josefsson from the Green Group. I'm an advisor to the group. If you could explain a bit more about point 9, not point 8, the Commission's view on the Parliament's request to limit the negotiations to counterfeit only. I think you were not very clear in your answer to Mr. McNamee, where you repeated that you will not go beyond the acquis, which was not the question. The question was whether you would respect the Parliament's point 9, sorry, to limit the negotiations to counterfeit.
Sorry, I think there's a misunderstanding. Point 8 is on counterfeiting. Point 9 is on copyright enforcement and acquis communautaire. And I mean, I can reconfirm that we will be fully in line with the acquis, but I suspect this is not what you want to hear. No, so what exactly is the question?
Sorry, it's point 9 in the resolution adopted. Calls on the Commission to continue the negotiations on ACTA and limit them to the existing European IPR enforcement systems against counterfeiting. That is point 9.
That's point 8, actually. But
then we have different versions here.
I pretty much have the official version of the Parliament, but okay, it doesn't matter. I mean, the reference is not important. I think actually, if you read the 9, which I don't know, perhaps is the 10 in your version, it should answer your question, because you have the Parliament writing urges the Commission to ensure that enforcement of ACTA provisions, especially those on copyright enforcement procedures in the digital environment, are fully in line with the acquis communautaire, demands that no personal searches will be conducted at EU borders, and requests full clarification of any clauses that will allow for warrantless speech searches and confiscation of information storage devices such as laptops, cell phones, and MP3 players by border and customs authorities. So, do we agree with that? Of course, totally. This is fully in line with the acquis. This is what I've even said in my early presentation.
And the previous point, if you read that?
Sorry?
And the previous point, if you read that, you don't see that there is a request to limit ACTA to counterfeit?
And how do you combine that with the next point? Because on the next point, it specifies what we should do on copyright, which is to respect the acquis, and I've said we're going to do exactly that.
So that is your comment to the Parliament's resolution that is inconsistent? Is that the point you want to make?
No, you said that. I didn't say that. I only said that if you read both, it's very consistent. It's simply spread on 2 paragraphs. The gentleman with a pink shirt?
Yes, just in follow-up to the question you were just asked. My name is Paul Meller, I'm a journalist, and could you just explain to those of us who are not experts in IP law, why is one legal instrument being discussed that addresses counterfeiting on the one hand, which includes things like counterfeit medicines that could kill people, and on the other hand, file sharing and copyright issues? What do the two have in common, and why on earth are you discussing them in the same context?
Well, the answer is simply that because both relate to IP enforcement or IP infringement, and because they are regulated internationally by the same treaty, which is TRIPS agreement of the WTO, to which all 150, I think, 3 members of the WTO have abided. And also there you have one instrument dealing with both. And I agree with you, of course, that the two nature of infringement are totally different. I'm not saying at all that it should be considered as the same thing. These are very different issues with different interests, etc. But from a legal instrument, if you want, point of view, they are both addressed in the same instrument, just like they are in WTO. Thank you. Any other question? Yes, gentleman with the white shirt.
My name is Benjamin Henrion. I work for the FFI. We have an association with 3,000 companies and many independent software developers. We are concerned that the current ACTA negotiations cover patents. One thing we are concerned is the level of injunction that a judge has to apply to suspicion of infringement. There was a hearing in the European Parliament in the Legal Affairs Committee about the review of the IPRED 1 directive. And one French expert said that the directive had the effect to change the level of injunction from quasi-certainty of infringement, to give an injunction, to suspicion of infringement. And in patent problems, it creates a disimbalance that can offer very powerful weapons to enforcers. Let's say in the United States, they have, according to latest statistics for the year 2008, up to 30% of what is called patent trolls. And on the US side, they have also a famous case which went to the Supreme Court, named the eBay versus Merck Exchange. Merck Exchange was a so-called patent troll that had a patent on the buy now feature, and they sued eBay for that, asking for shutdown of the eBay service. And the case went to the Supreme Court, where the court says that they were denying the automatic injunction. So now we have a conflict between the status of the law in the US and the one in Europe, because the IPRED 1 directive changed the threshold of injunction from quasi-certainty to suspicion. Now what the French expert said in the hearing was that all judges were reluctant to issue injunction in case of suspicion, because that might be too powerful. So do you intend to export IPRED 1 and this level of injunction to the United States and other countries?
Well, first of all, on patents, let's remember that we will not touch anything that is substantive as to patent right. This has to be clearly understood. Now, as you know, the substantive law in Europe on patent, on top of it, is not harmonized. But some enforcement measures through the IPR enforcement directive, what you call IPRED 1, which is the only one in force, have common rules, and we will base ourselves on these rules. If the United States have different rules, there will be a discussion, obviously, in a negotiation and arbitrage or changes. But we will clearly, we are defending our acquis. This is our negotiating guidelines, is to defend the acquis. So will I export it? I think it's too far-reaching, because it doesn't work like that. But will the existing IPR enforcement directive be the basis of the Commission negotiation? Yes, but not more. So, for instance, there are no criminal sanctions on patents. We're not going to defend that. Thank you. Sir, please. Blue sweatshirt.
My name is Martin Köhler from the Green Group in the European Parliament. Just to switch the question that was posed to you twice, do you think that the Parliament asked you to limit ACTA negotiations to counterfeiting? I would like to pose the question in this way. Second question, and you might not want to respond on them,